Hi, besties. Do you remember last week when I said that the judge in the case, Judge Lyman, was likely to grant the motions to quash for Brian Friedman's law firm? And that these last couple days of filings by Blake trying to reinforce that Brian Friedman is not a lawyer, but a PR agent. And that just wouldn't work because he's literally just defending his clients. Well, the judge was not moved by Blake's attempt on Friday to shift the needle in her favor. And do you remember how I said that because Wayfair stated that they didn't have any documents to give Blake Lively? Remember? For 1 through 4, like there was no documents of payments or anything because they were not made. Well, I said that that was going to be a win for her because they have nothing to give. Well, that's exactly what he did. So he gave her a technical win because Wayfair has nothing to give, and then granted the rest for Wayfair and cited that Blake Lively and Ryan Reynolds, whose name is on all of these subpoenas, by the way, have no right to the private records of Brian Friedman as a lawyer, and he was not moved whatsoever that Brian is not an attorney but a PR agent. It's ridiculous that they even tried to make this claim to get around the privilege, but the judge says they have privilege, period. And he also wasn't impressed or believing Blake's argument that she wasn't seeking privileged information because she's alleging defamation against Wayfair for statements made by Brian Friedman. So the only source of those statements could theoretically be Wayfair. And she's not suing Brian Friedman. So she doesn't get engagement letters between Wayfair's counsel and any content creators. He says that it may thus be relevant whether the negative comments made about Lively can be traced back to the Wayfair parties and their agent. It may be relevant whether the content creators have a relationship with Liner and Friedman and whether they acted at the direction and encouragement of Liner and Friedman. But she does not need discovery of the engagement letters of clients of the Liner firm to show whether this was the case. The precise terms of their engagement with Liner and the subject matter of their representations is not relevant. And information about the relationship between Liner and content creators can be obtained other ways. So he's not moved that she believes that Liner and Friedman funneled money to content creators. And then on five's requests 5 and 6, which relate to all documents involving you concerning digital online content creators and influencers, services concerning Miss Lively, Mr. Reynolds, and any of the Wayfair defendants in the digital campaign or the film. And 6 is from July 1st to 2024, all documents between you and any journalist, reporter, producer, editor, or any other representative of a newspaper, online news source, podcast, television network, or radio station, or any media form concerning or relating to the consolidated action, Miss Lively, Mr. Reynolds, or any of the Wayfair defendants. Isn't it funny how Ryan Reynolds is not a part of this lawsuit, but his name is all over it? And it's interesting because, I just shared the tea with you in my previous video about the MNTN IPO, Ryan needing to deflect the colossal failure of the marketing campaign that he orchestrated that made MNTN look terrible and made them look like really like a laughing stock. Like, that's the best you could do, Ryan, for this film. It was obvious to them that he was deflecting blame. And another tidbit was apparently this lawsuit is not being taken seriously by people in the banking industry because they are sort of appalled that Ryan is having his wife sue Wayfair for sexual harassment because a man looked at his wife. Like, it's a running joke, apparently, that you're really going to sue someone because he looked at your wife, Ryan. And don't be fooled. People behind the scenes, apparently, they know that all of this is Ryan Reynolds, and they know that Blake is just following his lead. And they also know that Ryan is doubling down, but he is a laughing stock, a laughing stock in the investment world at this point. He's becoming a laughing stock in Hollywood, and his reputation is sunk. Even though the lawsuit was dismissed, too much was revealed about his behavior and his efforts to cover things up that made people just realize he is a scam, allegedly. Okay. So, with requests to these communications between content creators and journalists, he says that it's granted. It could be considered at a later date if they were to amend these lists and add more people. But Lively has not demonstrated a need at this point to obtain those documents from Liner And there is a potential risk that the requests would encroach on the attorney client privilege, attorney work product doctrine, and attorney client relationship more generally. Documents in the possession of a party's attorney may be considered to be within the control of the party. Control does not require actual physical possession of the document at issue. Rather, documents are considered under a party's control when the party has the right, authority, or practicable ability to obtain the documents. At oral arguments, Liner confirmed that if Wayfarer parties asked Liner for the client file, it would provide the file. Liner also confirmed that if Friedman made a written communication to a content creator or a journalist to shape communications on behalf of the Wayfarer parties or within the scope of the representation, and if the Wayfarer parties asked for a copy of that communication, Liner would provide it to the Wayfarer parties. Thus, many, if not at all, of the documents called for by 5 and 6 should be obtained through requests to the Wayfarer parties if they had any such communications with content creators or press about the subject matter of these cases. These communications would presumably have been made in response of representing the parties and be available to the Wayfarer parties. If for whatever reason Liner communicated with the press and content creators about this case outside of their representation of the Wayfarer parties, such communications at this stage would seem minimally relevant to her claims. So he's not buying the fact that she is using this idea that he's a PR agent. He's saying that any communications he's doing is on behalf of his client and in defense of this litigation, and anything else would be irrelevant to her. There's a footnote here, and it says, Request 5 states that Liner does not need to produce documents in the possession, custody, of control of the Wayfarer parties, only documents uniquely retained by Liner. This is somewhat contradictory, as documents uniquely retained by Liner, meaning that the Wayfarer parties do not have a copy, would still be in the custody control of the Wayfarer parties if they are part of the client file. The court does not read the request to solely seek Liner's communication with content creators independent of its representation of the Wayfarer parties. But moreover, privilege concerns further weigh against the forcing counsel to disclose documents in control of Wayfarer parties. To the extent that a privilege is implicated, it would be the Wayfarer party's privilege to assert, and thus it should be asserted by the Wayfarer parties in response to requests to them. Attempts to subpoena a lawyer who either are actively litigating a case on an other party's behalf or who they're associated with trial counsel run a much greater risk of intrusion on attorney-client relationship than subpoenas to former lawyers or corporate counsel. So in this specific area in New York, they do not let or like when people subpoena lawyers because the lawyer is working for the client and the client has privilege. There's attorney-client privilege and there's attorney work doctrine. There's a work doctrine privilege. And if she wanted to get information from one of their former lawyers, she could. But in this case, he's saying they're not going to get them here because of privilege. The court grants Lively leave to propound renewed interrogatories or document requests to the Wayfarer parties for the documents or communications sought by requests 5 and 6 here. If there is dispute over the Wayfarer party's response to these interrogatories or related document requests, the issue may be raised with the court and the parties themselves may raise objections. Absent some showing that Liner has relevant information or documents that cannot be obtained through a request to a Wayfarer party themselves, there's no reason to resort to a subpoena to trial counsel, given the attendant risks to the adversarial process. She has leave to move for reconsideration of this ruling at a later date if necessary. He gives her all kinds of options to request a reconsideration and all of that. I mean, she could do that without him even saying that. There's a footnote that says Lively represents that she has already propounded an interrogatory to the Wayfarer parties requiring that they identify any content creators with whom they spoke. The court granted a motion to compel responses to a similar interrogatory regarding communications with the press. However, the Wayfarer parties' responses may not have included communications made by attorneys on the Wayfarer. 7 and 8, the motion to quash is granted with prejudice, meaning she cannot revive these ones because 7 and 8 are work product doctrine and attorney-client privilege, and it's little relevance to her claims. The purpose of attorney-client privilege is to encourage full and frank communications between attorneys and their clients, thereby promote broader public interest in the observance of law and administrative justice. And under federal law, the attorney-client privilege protects communications between a client and his or her attorney that are intended to be, and in fact were, kept confidential and for the purpose of obtaining or providing legal advice. Unless the communications are no longer kept confidential, the advice of counsel has been put at issue at 102, or the privilege has been otherwise waived. The communications are absolutely protected. So she was trying to get around this idea that they don't have privilege because he's not working as an attorney, he's working as a PR agent. But he's saying, no, 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 no. This man is working as an attorney in a case in federal court, and his communications with his clients is protected, my friend. And he's also saying that work product doctrine provides a more qualified protection against disclosure because this protects documents and tangible things that are anticipation of litigation and for trial or for another party or its representative. This definition does not apply only to counsel and documents prepared by agents to perform investigative or analytical tasks. So she's trying to sue them for defamation, but he says evidence regarding Friedman's statements are relevant to her retaliation claims under federal and state law, as well as her defamation claim under state law. The federal law of privilege applies, describing both defamatory and a continuation of a retaliation claim. He also pointed out that there's a point in here where Lively is trying to claim that she doesn't want any privileged conversations with his clients. However, an obvious source for information that Mr. Friedman would be sharing with the public would be coming directly from his clients in the course of seeking legal advice. And those would be absolutely privileged. And then a second source would be discussions with potential witnesses that are contacted in course of the investigating the allegations in her complaint. And those would be attorney work product. So they're both privileged. Lively suggests that the request may also uncover communications made to inform public statements rather than legal strategies. But the line Lively attempts to draw is vanishingly thin. An interview by Liner aimed at determining the truth falsity of Lively's allegations would presumably yield material that could be used both in defense of the Wayfarer party's position in this court and in defense of their position in the press. So basically, anything that he tells publicly in an interview is something that can be used for them in the court as well. So it's not that he's doing PR, he's just out there defending his clients. And that her attempting to claim that he's a PR agent literally, he says, is vanishingly thin. She does not assert defamation against Friedman personally, but against the parties, the Wayfarer parties. If the Wayfarer parties believe the statements were false and authorized or approved their making, they could be held liable regardless of whether Friedman himself had a basis for believing statements were false. The statements alleged to be defamatory relate to events as to which the Wayfarer parties, primarily Beldoni and Heath, were percipient witnesses. They could not have needed the witness interviews of Liner to determine whether the statements made by Friedman were true or false. They had direct knowledge of the events of which he spoke. Even if another witness told Liner that Lively was telling the truth, and Liner relayed this to the Wayfarer parties, it would seem minimally probative of the issue whether the Wayfarer parties believed Lively was telling the truth. Given the low relevance of the information to Lively's claims, the clear risk of encountering privilege and work product issues constitute an undue burden and must be quashed. And then they're trying to claim that they need to look at his mental state. But says even as to Friedman's own mental state, his client's belief based on firsthand knowledge would logically have greater weight than denials from other sources. Holding actual malice was insufficiently alleged when general counsel simply repeated the client's versions of events. So Wayfarer's communications with their attorney are now protected, and Blake does not get to find out what's being said. And Blake doesn't get to go after and claim that, this isn't Mr. Friedman acting in concert as an attorney, not as a PR agent. But Blake has already responded. It's like they already knew they were going to lose this because this was an obscene ask to a judge. He wasn't going to give him, the attorney, he wasn't going to break attorney-client privilege here. What she's asking the court to do is just turn him into a PR agent and ignore that he's litigating. and that he's answering questions that are his defense. And even in this denial or the granting of this motion to quash, he says that Mr. Friedman speaking to the press and answering to questions about the truth or falsity of her claims is the same as him using that same defense in court. So instead of taking this ruling on the chin and accepting the loss, now because she can't get access to their communications, now she's going to continue to attack Friedman. And so now they've filed a motion for sanctions the second time. So they, by the way, the judge hasn't even ruled on the first motion for sanctions. And now she's filing a second motion for sanctions against the defendant's counsel. They lose the motion to quash, and she retaliates against them because they had a right to file the motion to quash. She doesn't get to have and access his attorney-client privilege documents, and he gets to defend his attorney. He gets to defend his clients. So now she's going to moves pursuant to New York Rule of Professional Conduct 3.6 and Federal Rules of Civil Procedure 17F for sanctions against plaintiff's counsel Brian Friedman. She respectfully submits that the court should impose sanction against Mr. Friedman as a consequence of his relentless media campaign to harm her character, credibility, and her reputation. And honestly, this motion for sanctions is absolutely ridiculous. I have never seen anything like this. It is the same argument over and over again. And it's the same statements from February and from March that they have been trying to claim are retaliatory. And it boggles my mind that they continue to file these. It's the same statements. They brought this up in the first motion for sanctions, and it's because he discussed her deposition. Going to probably take some legal actions that are beyond the bounds of decency, and we'll see if they can try to avoid a deposition. A 30-minute interview on a podcast hosted by Billy Bush. And he said, documents don't lie, people do. I wouldn't want to be on the wrong side of history here. Documents don't lie, people do. That's true. Or February 19th, he said her claims were false, filled with unsubstantial hearsay and unnamed persons who are clearly no longer willing to come forward or publicly support her and lacking actual evidence. Documents do not lie, people do. He's defending his clients. People in March 19th, this is about Ryan Reynolds. That's weird. Why is Ryan Reynolds being brought up here? He brought this up in Ryan's motion for sanctions, that Ryan, as someone who believes that bullying is acceptable, alongside his false insistence that Mr. Reynolds was publicly documented to be a key player whose fingerprints have been all over the smear campaign against Justin and Wayfarer since day one. He is, that's true. March 20th, a self-concocted disaster she initiated. She's being a privileged elite whose motion to dismiss twisted and curated the law to fit her personal agenda. April 4th, she's attempting to divert the public's attention from the receipts, the actual documents, the video footage, and the additional evidence made it irrefutable that there was no sexual harassment and that her own conduct was responsible for the organic backlash she received. She does not need discovery to find out who smeared her, just Amir will do. That's true still. None of that is false. He characterized Miss Lively as belonging to a circle of Hollywood elites seeking to advance false and harmful claims and block access to the court system and weaken our nation's constitution. That's true too. May 8th, he talked about holding her deposition in Madison Square Garden. That was a joke. Oh my God. Saying TMZ, June 10th, he said that she's afraid of the truth and we're going to see if she's going to appear at her deposition or not. And that she's accused very good people of a smear campaign and accused a terrific young man of sexual harassment. I mean, that's just speaking about the lawsuit again. And then Miss Kelly opened the podcast by conveying that Mr. Friedman is waging the war against Blake Lively, who he believes is not a good person. And then Miss Lively was referred to as being a bitch, which he asserted in a lengthy discussion. He never said that, and he never even called her a narcissist. How she's behaved and how she's treated reporters and how she's treated people and how she's treated individuals and how she's treated waitstaff and others and saying it's not okay, we don't like you. That's all that's being said. So apparently making these statements is trying to ruin her credibility, and that he's violated these rules and they're designed to suggest that she's lying and she's afraid of the truth and they're not true, that he's violating, that she's a person of poor character in contrast with the good character of his clients. I mean, that's true. He's defending his clients, trying to make Baldoni the victim of a powerful bully. It's a defense strategy. All of this is just asinine. It's just another way to get the, hey, judge, we've got a motion, we've got sanctions for Rule 11, and now we're going to bring them for Rule 3.6 in case you're wondering, because he's trying to undermine her credibility. All of these statements were old. They've been out there for how long? And I mean, he's even got an issue with claims about Mr. Reynolds going to Saturday Night Live and making jokes about the situation. Friedman's public statements regarding Mr. Reynolds' appearance on SNL had been part of his lengthy campaign to tar Miss Lively as a liar. Okay, she is lying. She's lying about all of this. Every last bit of it. She and Ryan are liars. The a bark dog hollered. A hit dog will holler. And that's when someone's guilty or they feel targeted by a statement, they act defensively and they show a strong reaction because the statement applies to them. A hit dog will holler. That's what they're doing. They don't like that they're being called liars, and Miss Lively can't accept that we had organic reactions to her, and she still is just going to try to get them on sanctions on something. And every time she does this, the judge denies it. And this is literally after the judge told her that he has a right to defend his clients. And their defense is that she's a liar. We don't need any evidence from Friedman to know that she's a liar. And so now that she's sat for her deposition, him claiming that he was concerned that she would dodge her deposition, well, it's fair. We did have concerns, and she did change the date multiple times. He's welcome to make those claims. Anyway, Blake Lively cannot accept the court's ruling, and he has a right, Mr. Friedman, to speak candidly to the public, to answer questions. If he had concerns about her showing up for the depositions, those were his valid concerns. She has now shown up for the deposition. So now Blake's like, you better sanction him. It's such a game. But this is a win for Wayfarer, a win for Friedman. And it doesn't matter, this motion for sanctions. It's stupid. It's not going to go anywhere. They're not going to win it. That's my opinion. So what are your thoughts? Let me know in the comments below. Please make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed, and click the bell so you never miss a video. Thanks so much for watching. Bye, besties.